Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Where are we coming from today? Come on, you know where we're at. We are at Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. And hey, last night I was here, shot this video right here. Went home after the class I had to teach, doing some editing, and I got to doing some thinking about this incredible opportunity that's been presented to our Attorney General because of the President's executive order. Now, I get that a lot of you were a little leery about Pam Bondi. There was great trepidation about whether or not she was the right choice for Attorney General, and I understand where you were coming from, and I'm not saying you didn't have good reasons. But this executive order by the president really gives Pam Bondi an opportunity, doesn't it? It gives her an opportunity to prove to us whether or not she truly is the Second Amendment champion that she claims and this administration claims she will be, or if she's the same old Pam Bondi that many of you were worried about. So today, let's spend a few minutes and let's talk about why it's time for Pam Bondi to put up or shut up. Okay, America, we're talking about President Trump's executive order dated February 7th, which essentially ordered the Attorney General over the next 30 days to do a complete autopsy on everything that's gone on with our Second Amendment rights during the previous administration. The actual order tells the Attorney General to do the following. Within 30 days of the date of this order, the Attorney General shall examine all orders, regulations, guidance plans, international agreements, and other actions of executive departments and agencies to assess any ongoing infringements of the Second Amendment rights of our citizens and present a proposed plan of action to the President through the Domestic Policy Advisor to protect the Second Amendment rights of all Americans. And then in addition to that, the president specifically ordered the Attorney General to go look at the following areas. 1, all presidential and agencies' actions from January 21 through January 25 that purport to promote safety but may have impinged on the Second Amendment rights of law-abiding citizens. 2, rules promulgated by the Department of Justice, including by the Bureau of Alcohol, Tobacco, Firearms, and Explosives from January 21 through January 25 pertaining to firearms and/or federal firearm licensees. 3, agencies' plans, orders, and actions regarding the so-called enhanced regulatory enforcement policy pertaining to firearms and/or federal firearm licensees. And then the 5th one that we're going to focus on today, this one, which is huge, 5, the positions taken by the United States in any and all ongoing and potential litigation that affects or could affect the ability of Americans to exercise their Second Amendment rights. Now, there's a lot of other specifics in that order, but for purposes of our discussion today, those are the ones we're going to focus on. Okay. So as I was geeking out last night while editing this video right here, I began to come to this realization that this is an amazing opportunity for the Attorney General, and I decided I would put together a little list of things that perhaps she could do. Now, I broke them down into 3 categories. The easy stuff, that is stuff that's kind of actually easy to do. The stuff that's not too difficult to do, but a little out of the ordinary. And then the stuff that's going to be really, really difficult to do, stuff that she may not even be willing to try to take on, and you will understand why. I am not saying that any of these are great ideas or bad ideas. I am assessing these based upon how easy it would be for the Attorney General and or the federal government to implement some of these changes. Okay, here we go, the easy stuff. Number 1, recall the rule on pistol braces. Hey, it's pretty simple to recall any of these rules. All you need to do is file written notice of your intent to withdraw the rule from the Federal Registry, allow for public comment. We know how federal agencies don't listen to public comment anyways, and after the deadline is reached, the rule comes off the Federal Registry. The pistol brace rule has been shot down by court after court after court. It has no place in the Code of Federal Registry, and it should be pulled immediately. Number 2, recall the rule on the engaged in business or zero tolerance on FFLs. Again, same simple process, notice, opportunity to be heard, pull the rule. This rule has been used to run hundreds and hundreds of reputable FFLs out of business, okay? And this is was going to be a tactic of the warfare on home-based FFLs. We could stop that insanity by simply withdrawing that rule. Number 3, recall the rule on force reset triggers. I mean, come on, once again, there hasn't been a single court to basically uphold this. And the problem is if you really want to ban force reset triggers, you're actually going to have to go in and change the federal definition of machine guns or automatic weapons. Because at the current time, what the law prohibits and what force reset triggers and bump stocks do does not disturb the meaning of this law. Number 4, concede the arguments on Daniels versus United States and Range versus Attorney General of the United States. Yeah, these are both big cases that deal with non-violent felons. Actually, Daniels deals with a cannabis user. Range deals with a non-violent felon. Both of these cases were sitting right there on the front door of the United States Supreme Court. They got GVR'd back down to their respective districts following Rahimi. The United States could concede error in those cases, and thus they could become the law of the land. Okay, now let's think a little outside the box. That's the stuff that we think is pretty easy to do. So let's think a little bit outside of the box, like this. File amicus briefs in support of the Snope v. Brown and Ocean State Tactical v. Rhode Island cases. I mean, after all, you could file a motion for leave to file an amicus brief. The United States Department of Justice could weigh in and say that this is an issue that absolutely positively needs to be resolved and encourage the United States Supreme Court to actually accept review of these cases. Now, is it going to make a difference? I don't know. Trying to figure out the Supreme Court has been next to impossible, but it certainly would be a refreshing change if the Attorney General's office and the ATF started as vehemently defending the rights as they are going after supposed criminal conduct. Number 2, file amicus briefs on Miller v. Bonta and Duncan v. Bonta, or any other case down at the state level in which these issues are kicking around. If the ATF took more of a sheriff's office approach, which is, yes, we are very serious about busting down on criminal conduct, but we are equally serious about preserving constitutional rights, you could actually begin to see amicus briefs from the United States Department of Justice who will say, hey, listen, we're all in favor of trying to curb gun violence, but we're not in favor of doing it through unconstitutional methods. And what these states like California and Illinois and New Jersey and New York and Maryland and Washington are doing is unconstitutional. Okay, and then let's get to the stuff that is going to be difficult for either one of two reasons. Either A, politically, it would be a massive hot potato, one that I'm not sure if this administration totally wants to accept at the current time. Or it's going to take a massive movement of legislation, which, as we know, getting the feds to pass any type of significant legislation is next to impossible. But since we're being hopeful, let's talk about them anyways. Number 1, concede the arguments on United States v. Brown and United States v. Morgan. These are two cases that have found that the federal ban on machine guns is in fact unconstitutional because it lacks historical analogs. Could the United States government at this point concede those issues? They could. Now, what sort of headlines would it lead to? I think we can all imagine. And again, I'm not saying that it's the improper thing. Legally and constitutionally speaking, it probably is. But there is a political overtone to all of this, is there not? Number 2, withdraw the rule on unfinished frames and receivers. Okay, why is that so much more difficult than withdrawing all the other rules? Well, because we've already had oral arguments in the matter of Garland v. Vanderstock, which means the United States Supreme Court has already expended considerable resources to have heard this issue. The rule could be withdrawn after the court issues its ruling, but to go out and moot the case by withdrawing the rule right now, I think is playing a little bit of gamesmanship with the United States Supreme Court at the same time that we're hopeful they're going to accept review on a lot of other very important cases. So I'm not sure that politically would be the best move. Could the Attorney General's office wait for the ruling in Vanderstock and then decide whether or not to withdraw the rule? Yes, because again, all it takes to withdraw a rule from the Code of Federal Regulations, as long as you comply with the APA, which is provide written notice and a meaningful opportunity for the public to be heard with an acceptable deadline. Once the deadline is reached, the agency can make that decision. Number 3, concede on Reese versus ATF. Yeah, okay, this is going to be another political hot issue. This is the ruling that says that the federal handgun ban on those 18, 19, and 20-year-olds actually lacks any type of historical support, and for that reason is in fact unconstitutional. Now, it's going to be very interesting with this issue because if you go back and you look at the historical analogs, the argument is very, very solid for 18 through 20-year-olds. But it's a political issue as well, okay? Now, just to give you a little fodder, Attorney General Bondi, who I'm sure is not watching this video, you're probably busy enough doing more important things than watching this. But I do find it odd that in many states, they don't believe that 18, 19, or 20-year-olds are mature enough to purchase a handgun. But in those very same states, they believe that 13 or 14-year-olds are mature enough to mutilate their bodies. That 14 or 15-year-olds are actually old enough to run away from home and actually get gender transition surgery. sponsored by the state. Number 4, you could remove suppressors from the NFA. There is ample reasons to remove suppressors from the NFA. They candidly should have never been there before. Now, unfortunately, we already have a Fifth Circuit 3-judge panel out there that said, hey, the Second Amendment doesn't even apply to suppressors. So remove them from the NFA and you really are kind of out in the hinterland where states could get pretty evil on it. However, here's the big problem. To remove them from the NFA, you actually have to change federal legislation. You actually have to amend the National Firearms Act of 1934, which means you're going to have all the votes and the political clout, both in the House and the Senate, to get this done, which is like moving mountains. So for that reason, although we think it's a fantastic idea, we do recognize it is a monumental task. And then finally, and you guys all want this, abolish the ATF. Yeah, listen, I get why a lot of you want to abolish the ATF. And certainly when you do stories about like what happened to poor Mark Manley out there in Maryland, there's lots of good reasons to abolish the ATF. However, again, this is an administration that ran on law and order. Eliminating a law enforcement agency is not going to have a good political look to it. And yes, unfortunately, we have to look through it at that lens as well, because that's the lens they're looking at this as well. Okay, now with that in mind, we've already seen with the earlier part of this list that a refined and more in-tune ATF could actually become an ally of Second Amendment rights if run correctly. So perhaps the best thing to do is actually find a refined ATF, and we're going to find out if we have a true Second Amendment advocate in the Attorney General's office. And of course, we are still awaiting who the ATF director will be. But in order to abolish the ATF, you're talking about, again, overriding massive federal legislation, which means it's going to be like moving mountains, which means it's going to be nearly impossible. It's a short list. Now, listen, I'm sure we missed a bunch of things, and I bet you guys all got some really good ideas what the Attorney General could be doing as well. So if you do, tell us all about it down there in the comments section. Listen, we're going to go ahead and link up the president's executive order again down below so that you can geek out on it for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to our monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.